The President, please be seated. The court is now back in session. As scheduled, today we are going to hear the testimonies of witness Salotban. Questions continue to be put by counsel for Khieu Samphan. We then proceed to hear TCW 504. Court greffiers are now instructed to report on the attendance of the parties to the proceeding. Psychologically, Mr. President, the co-prosecutors are present. Mr. Ieng Sari, Khieu Samphan, and Noon Chia are present. Counsels for Ieng Sari are present. Counsel for Khieu Samphan is present. The National Council is present. And counsels for Mr. Noon Chia are present. Civil party counsels are present. Witness who is going to be heard after witness Salotban is in his waiting room, awaiting call from the chamber. The witness has no relationship or is no way connected to any of the civil parties admitted before the chamber, and the witness has already taken an oath. The President, thank you. Counsel for Noon Chia, you may now proceed.
Thank you, Mr. President. Good morning, everyone. A very brief point of order, if I may, Your Honors, completely unrelated to this witness or the next witness. It's actually related to something that occurred in the courtroom on Monday, something that we feel requires an extremely brief comment. On Monday afternoon, as my colleague Mikhail Pestman was discussing our team's consistent position with respect to the effect of political interference at the tribunal, Judge Cartwright, visibly, and I was looking directly at her, shook her head from side to side and mouthed the words, blah, 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 as if to indicate, I don't quite know, that is the application that we have today, Your Honors. Given the obvious problems associated with such unrecorded gesticulations, we now seek some clarification from the chamber, or from Judge Cartwright herself, if she's so inclined. Was that episode that I just described, was that simply her usual manifestation of disdain for defense counsel on the Noon Chia team, or was it in fact an expression of her position on a matter that, according to the Supreme Court chamber, is still sub judice with this chamber, and that is, of course, the effects of RGC interference, if any, on these proceedings? What precisely was Judge Cartwright attempting to convey through her now open, and I would say almost de rigueur, expressions of exasperation in response to submissions from this corner of the stage? What is it exactly that Judge Cartwright finds so objectionable about the Noon Chia defense team? It is, of course, presumed that the judges of this bench are impartial. However, we submit that such obvious expressions of disapproval are problematic at best and potentially far more troubling. We do obviously, as a starting point, expect to plead before a dispassionate bench. So if we can't be assured of that basic foundation at a minimum, it makes our position, our client's position, on this stage precarious, to say the least. Your Honors, despite a diligent search over the holiday, I wasn't able to find any international jurisprudence precisely on point, but a certain secondary source almost immediately sprang to mind, and I suspect the younger players on the stage will be familiar with this, and I'm quoting now, "Some musicians cuss at home, but are scared to use profanity when up on the microphone." And that, of course, for the uninitiated, is Dr. Dre of NWA from Express Yourself, straight out of Compton, 1980.
The President, Counsel, could you please be slow in your pace? We haven't had any rendition of your application because we Cambodian judges feel that most part of your last statement has been missing, and we are not aware of what you are talking about. Please be more precise and make sure that your statement is short and slower. Our knowledge is not as high as that of yours, and please be reminded that counsel is talking to the bench, not talking to yourself. Please repeat your statement and speak at a very slower pace so that parties can understand your message and that parties will be able to respond to your statement. This is to avoid whether this is your observation, your application, and whether the chamber is needed to rule upon it.
Thank you, Your Honor. I do apologize. I do have a tendency to speak to myself. Your Honors, I just repeat what I said. Despite a diligent search over the holiday, I wasn't able to find any international jurisprudence precisely on point. But a certain secondary source almost immediately sprang to mind, and that, as I mentioned, I suspect the younger players on this stage may be familiar with. I'm quoting now, "Some musicians cuss at home but are scared to use profanity when up on the microphone." And that is Dr. Dre of NWA, Express Yourself, straight out of Compton, 1988, I believe. So my application, to be very clear, my application this morning is that perhaps in the future, Judge Cartwright could be advised, and again I'm quoting Dr. Dre, to express with her full capabilities. And that is to say, perhaps she could verbalize her personal and or judicial positions, as the case may be, with respect to our team, if for nothing else, for the sake of the judicial record, the record in this case, which we must go on. Thank you, Your Honors. That's all I have today.
The President, co-prosecution, International Co-Prosecutor, you may now proceed.
Bonjour, Monsieur le Président.
Good morning, Mr. President, Your Honors. Once again, the defense for Nunchia has just conveyed its consistent strategy with respect to this bench. They have talked about the usual expression of disdain vis-à-vis their defense team. I believe that this remark is entirely inappropriate. All the more so because the defense have been given the opportunity to present their arguments, have been given the opportunity to exercise their rights and to question the witnesses. I do not understand what is the legal basis of that comment, and I believe that there is none. Therefore, the strategy to try and demonstrate that Nunchia is a perpetual victim of this chamber is entirely inappropriate, and I believe that the bench should consider imposing a sanction to the Council of Nunchia, who is incessantly raising such inappropriate comments. Thank you.
The President. Counsel, you may proceed, but advise the chamber how much time you would need to have the final words on this. And please tell us the duration of time you would like to be on your feet and how many more times you would like to be on your feet on this.
Your Honor, I'll be extremely brief. In response to what my colleague...
The President, we haven't heard from you as to how much time you would like to address this and how many times more.
1 minute, Your Honor. In response to what my...
The President, how many times would you want to be heard on this?
1 minute?
The President, I'm talking about frequency. Yes, you are talking for 1 minute, but how many often would you have the floor for this?
I'm afraid I don't understand. 1 minute.
លោកនិយាយ1 minute ប៉ុន្តែលោកនិយាយប្រហែលដងទៀត
The President, I understand that you are talking for 1 minute, but would you like to have this the last floor for your comment, or would you like to have the floor again after that 1 minute?
Well, as a matter of fact, I would like to have the floor at a later stage in regard to the message I sent to the senior legal officer, but with respect to this point, I only need 1 more minute. Very briefly, to respond to my colleague across the stage, this application is based on the accepted fact that judges of the tribunal must be, they're presumed to be, impartial, and that expressions, verbal or otherwise, can indicate that perhaps they are not. So that is the point that I'm trying to make, that Judge Cartwright has consistently made non-verbal expressions from the bench since the start of this trial that suggests a personal bias, against the members of our team. So that is the legal basis of my submission. And I would simply ask that the Chamber advise Judge Cartwright to the extent that she's able to refrain from making those expressions in the future. Thank you.
The President, the position by counsel for Nuon Chea concerning Judge Silver Cartwright is groundless. It is a public allegation against the judge of the bench, and for that reason the Chamber hereby rejects such allegation rather. We would like to proceed to counsel for Khieu Samphan to proceed with their questions to witness Salotban. Counsel is allocated the remaining 1 hour and 10 minutes to put questions to the witness. You may proceed. Counsel Kung Samon. Thank you, Mr. President, Your Honors. Good morning, Mr. Salotban. I would like to proceed to some additional questions to you. Before yesterday, we left off with your role as the guard and the location of the headquarters of the party before 1975. My next question is about the meetings. The meetings between or before the 17th of April 1975. You responded to questions put to you by the co-prosecutor concerning the meetings with Pol Pot, in which you indicated that there were 1 or 2 secretaries of zone to attend the meetings, and the meeting was not very important. When you refer to the head of zones or secretary of zones, who were you actually referring to? Were the members of the standing committee, secretary of any committee? Response. The secretary committees included the chief of the zones, the deputy chiefs of the zones. One or two of them would be attending such meetings. Question. Could you describe to us the functions of each chairman of each zone? Response. These people were in charge in all aspects. Question. Including the military? Is that so? Response. Yes, it is. Question. With regard to your testimonies before the chamber, of course, in response to the questions by the prosecutor on the 7th of April 2010, document E3/446, you stated that the meetings between Pol Pot and the head of the zones concerning the attack, because the attack of Phnom Penh was nearing. How did you know the attack was nearing? Response. The term preparation to attack suggests that, so far as I recollect, the Mekong River was liberated. The ships of the American imperialists were no longer allowed to transport goods or other things except the airplanes. Question, could you please be more precise? What you mean by the Mekong River being liberated? Response. The Revolutionary Army attacked the Mekong River primarily in order to cut all the routes for the goods transportation by the American imperialists, and they managed to control the whole river all the way to Nhat Luang. Question. So when you refer to the liberation of the Mekong River, you are referring to the victory over the Mekong River after the attack by the Revolutionary Army. However, when we're referring to Mekong River, we are talking about the lower Mekong River and the upper Mekong River. So are you now referring to both of them? Response, yes. And I wish you also add that the army did not only attack the ships, the imperialist ships, they also attacked the ships belong to the Lon Nol soldiers, the ships that docked on the Mekong River all the way to Kampong Cham. So in total, 90% of the river was under control of the army. Question, can you tell us the time when these attacks took place? Response, the severe attacks took place between early 7 rather early April 1975. Question. I would like to go back a little bit to the small meetings you indicated there that were attended by 1 or 2 people. Where were the meetings held? In the headquarters. You indicated that there were a few huts, 4 or 5 huts in the headquarters, and that some of the huts were for the guards and one was for kitchen. Could you please tell us in which location the meetings took place? Response. The meetings were held in the hut reserved for meetings, and the meeting at that time were for the preparation to attack Phnom Penh. The meetings were conducted in a 5 by 5 meter hut. Question. Could you tell us more about the physical appearance of the hut? Was it the same as the one you described to us on Monday?
Yes, they were. Council, thank you. Could you please tell the court about the guarding timetable and about the number of guards in each time? Witness. Allow me to describe the guarding procedures. The importance was about the people, the local people, the villages that we were taking charge of were those villagers who guarded the place. It was the responsibility of the village where the meeting was to be held. The responsibility was about the security. I had minor responsibility. I, as well as the cook, also guarded the place. The cook did not only cook. Everyone was watching to see whether there was any person entering the place. And in total, there were not more than 10 people guarding the place. Council, can you clarify again whether there were 10 people guarding in one time? Witness. There were only 2 or 3 guards with arms or weapons in their hands.
បាទចឹងខ្ញុំសូមបញ្ជាក់សារឡើងវិញថា
Council, I want you to confirm with you that there were only 2 or 3 armed guards. Others who also guarded the place were Cook or you. Is this correct?
បាទ
Witness, yes, it is. Counsel, thank you.
លោកអាចបញ្ជាក់ពីការឈរទីតាំងឈររបស់អ្នកយាមបានទេឧទាហរណ៍
Can you tell us about the position
ដឹកនាំ
of those guards? For example, when those leaders were meeting in a hut, where were those guards positioning?
អ្នកយាមនោះ
Witness,
ឈរ
those guards were standing
5-15 ម៉ែត្រ
somewhere
អត់ឲ្យអ្នកណាឃើញទេ
about 15 meters away from the hut, and they were not to be seen by others. They were
កន្លែងណាមាន
hiding
នឹងទៅ
in bushes.
ដោយថា3នាក់នឹងយាមទៅយាមជារបៀបបដិហៅថាណែត្រីកោណបាទមកជើង
For example, if we had 3 guards, they would be positioning in a triangle shape,
ពីកន្លែងធ្វើការ
and they were to be hiding in bushes, and at least they were to be 15 meters away from the hut where the meeting was being held.
បាទសូមអរគុណលោកអាចបញ្ជាក់ទេ
Counsel,
លោកមិនលោកបញ្ជាក់
thank you.
យ៉ាងជិតបំផុត15ម៉ែត្រ
You said at least their positioning was to be 50 meters away from the hut. And what is the farthest position they could be?
ឆ្ងាយបំផុត50
Witness.
ទៅ60ម៉ែត្រ
The farthest position was about 50 or 60 meters away from the hut.
បាទសូមអរគុណ
Counsel, thank you.
លោកសូមលោកជួយបញ្ជាក់ទៅក្រុមប្រឹក្សាជំនុំជម្រះផងថាចុះបើសិនជា
Can you indicate to the chamber
ឆ្លៀតឱកាសមកលោកស្ដាប់
that if
ពិភាក្សាការប្រជុំ
the guards
តើក៏អាចធ្វើបានទេ
attempted to spy or to hear about the meeting, was it possible for them to do so?
បាទដូចជាមិនអាចទៅលោក
Witness,
លោកបានទេបាទ
I don't think it was possible for them to do so. No, I don't think so.
ជាក់ថាក្រមតំណាក់ការពារផ្ទាល់
I confirm that
អាវឈ្មោះហ៊ួនហ្នឹងក៏
even the personal security guard was not allowed to be near them.
បាទសូមអរគុណលោក
Counsel, thank you.
ខ្ញុំបាទសូមចូលទៅចំណុចមួយទៀត
I am now moving into another topic.
លោកសហប្រញ្ញាអន្តរជាតិបានរំលឹក
The international co-prosecutor reminded EU concerning
សម្ភាសរបស់លោកជាមួយនឹងការិយាល័យ
your interview with the Office of the Co-Investigating Judges, the interview of the 7th November, rather April 2010, document DE3/39/36, rather E369/36. In the interview, you recalled the role of Mr. Keo Sampon.
តាមដែលលោកបានគិតឃើញលោកសហប្រញ្ញាបានសូមឲ្យលោកបញ្ជាក់នៅត្រង់ចម្លើយ
The international co-prosecutor
នៅក្នុងលេខ
asked you to confirm your answer, that answer 37 in that interview, and the EIN in Khmer is 0049 29 62.
ភាសាបារាំង
The French EIN 0052
95
95 10,
និងភាសាអង់គ្លេស
and the English EIN 0050 3164.
លោកបានបញ្ជាក់ថាលោកខៀវសំផនមិនមែនជាសមាជិក
You indicated that, and rather you confirmed that Mr. Kirsampon was not a member of the standing committee. Later on, the international co-prosecutor asked you to confirm your answer, that is answer 37, concerning the role of Mr. Kirsampon.
បានឆ្លើយថាលោកខៀវសំផន
In that interview, you said, you answered that Mr. Kirsampon
លោកនៅចាំត្រង់ចំណុចនេះទេ
was the president of the state presidium. Did you recall this?
បាទចាំ
Yes, I recall that, says the witness.
បាទសូមអរគុណឥឡូវខ្ញុំបាទសូម
Counsel, thank you.
ឯកសារនេះដដែលតាក់ទងទៅនឹងចម្លើយ40
Concerning the same document, at question answer 40,
ខ្ញុំបាទសូមលោកប្រធានអនុញ្ញាតឲ្យ
and with President's leave,
នៅឯកសារ
I would like these documents to be put on the screen. Again, document E3/446 at question answer 40. President's assistant is now instructed to put up document E3/446 or D369/36. Counsel, Mr. Salot Ban, can you read the document that is put before you? Otherwise, I can provide you the hard copy if you have difficulty in reading the one on the screen. Witness, yes, I can read that. Counsel, can you read? Witness, yes, I can. Counsel, so can you read the portion in the red box? Witness, what was the power of the state presidium? Answer, like in the front, he had no power. Counsel, thank you. President, please wait, counsel. Yes, international lead co-lawyer, you may proceed.
Yes, good morning, Mr. President, Your Honors. I have simply two questions that were not translated into French. But I, however, did hear what you said to me in French afterwards, but there I have two translations of questions are missing.
President, Defense Counsel for Mr. Kilsampon, you may continue your questioning. We may examine the transcript afterward because it seems that the problem applies only to you, Counsel. Maybe your headset ran out of battery. Counsel may continue. Counsel, thank you, Mr. President. I now continue my questions. Mr. Witness, based on what you have read, do you still stand by this answer of yours? Witness, yes, I do. Counsel, thank you. Now I will ask you about keeping secrecy during the Democratic Cambodia regime. You answered in this court and you indicated time and again that you minded only your own business and you did not want to know about others. On Tuesday, the 24th of April, in the morning session, you said that the situation at that time was secretive. And on Monday in the morning, the transcript in Khmer at page 34, line 13, you said that we knew our own business and we were to know our own business only. That was the general principle to keep secrecy. I have a number of questions concerning this point for you to confirm to the chamber. Was it the theory to keep secret as part of the study session? Witness, the theory was studied during the study session on a daily basis. The President, International Co-Prosecutor, you may proceed.
Thank you, Mr. President. There is one point of difficulty here, is that the witness answers before the light goes on. So this does not allow me to object to certain questions that seem to be leading, or at least not to object to these questions in a timely manner. So the witness answers before I get the French translation. So could there be a bit more delay before the witness answers? Because on several occasions, questions have needed to be confirmed, and I could have made an objection, but I received the translation too late.
The President, thank you. Counsel and witness are now advised to wait or to pause between question and answer. I have informed the technician concerning activating the mic. I have noticed that a witness has been doing very well. That is, he is waiting until his mic has been activated. And as for counsel, you are advised to pause before you put another question. Council, thank you, Mr. President. I believe I am at the lowest pace. I have a given time. I will now continue my questions. Mr. Witness, can you tell us about the principle of keeping secrecy? Was it stipulated in any rules within the framework of democratic Cambodia? Witness, we had a slogan: disclosing secrecy will lead to death. Keeping secrecy will earn us 80% of victory. Council, thank you. I have heard that you said during this court hearing about the 12 morals. Was the principle of keeping secrecy the same as the 12 morals you mentioned? Witness, yes, it was. Council, so you are saying that the two principles were the same? Witness, yes, they were. Council, thank you. Concerning the principle of keeping secrecy, is it fair to say that we were not supposed to consider others' business? We were supposed to consider our only our own business. Was it a principle within the framework of democratic Cambodia? Witness, yes, it was. Council, thank you, Council, for your questions to the Chamber. Mr. President, I have no further questions. President, thank you, Council. Thank you, Witness. Yes, International Prosecutor, you may proceed.
Thank you, Mr. President. I just require a bit of your time to provide clarification to the Chamber and to the parties. Monday, we spoke in depth about Mr. Kung David. And for the transcript, I would like to draw the Chamber's attention to the fact that there exists a document on the case file, document E3/129, also D108/26.26, which is a prisoner's list at S21. And some of the intellectuals coming from France are in this list, and Kun David is listed as number 36 in this list. And Ku David entered S21 on 12 December 1976. This is also in the list, and I wanted this to be clear, and I wanted this to be in the record for each party to be informed of this.
The President. Thank you. Thank you, Mr. Salotban. Your testimony has now been concluded. The Chamber would like to express its gratitude to you for your time giving testimony in this court on the basis of what you knew, you remembered, and you experienced. You now can be excused and go back to where you want to go. We also thank the Duty Council for your time being here. Court officer is now instructed to facilitate with Wesu to help this witness return to his place. The President. Next, the Chamber will hear TCW 504. Court officer is now instructed to bring in TCW 504. Or please wait. I have noticed Defense Counsel for Mr. Nunchi is on his feet. Yes, Counsel, you may proceed.
Thank you, Mr. President. Your Honors, I did send an email yesterday to the senior legal officer indicating that we take the position that there is an issue with respect to self-incrimination with this witness, and that we ought to, pursuant to Rule 28.8, briefly move into an in-camera proceeding to discuss that. I think everybody was copied on that email.
Yes, International Co-Prosecutor, you may proceed.
Yes, indeed. Thank you, Mr. President, and good morning. We were indeed copied on that email, and I'm on my feet simply to state that we don't consider that there is a need for any hearing. Just as a matter of order, the statement on the basis of which this belated application is made was first disclosed in 2007. We did recently disclose, about 2 weeks ago, a unredacted version which we became aware of. But there is nothing new as far as the issue that my friend is raising is concerned. Our position is that if you look at the statements of this witness on their face, there is simply no basis to make the application that my friend is making. But in any event, perhaps all that needs to happen is that if the Chamber confirms that the witness has been advised or has had access to legal advice, then this issue is superfluous and there's no need for an application. We acknowledge that there is some difficulty with Rule 28 insofar as Sub-Rule 8 technically requires counsel to make these applications where they consider that an issue of self-incrimination arises. We say that no such issue arises, but also we say that there's no need for counsel to keep making these applications if the Chamber confirms that under Rule 28.2, witnesses are informed of their rights and of the privilege against self-incrimination. So there's no need to go into a closed session. And just lastly, I do note that this issue has been dealt with. It was in closed session, so I'll refrain from quoting from the transcript, but I think Judge Cartwright's comments make it clear that applications should be made in advance, and I think that email can be considered that application or the raising of the issue with the trial chamber. I don't think we need to go into a closed session to deal with this any further. Thank you.
Your Honor, if I may reply.
The President. Yeah, International Lead Co-Lawyer, you may proceed.
Yes, Mr. President. We also do not see any ground for this application for an in-camera session. We don't understand the reason for this. The witness was informed of his rights, and the Chamber can inform him of his rights again. He is perfectly aware of all of this, and he is aware of the reach of his testimony, and we all are mindful of being transparent, so there's no reason to have an in-camera session for this witness's testimony.
The President, Counsel for Noon Chia, you may now proceed.
Thank you, Your Honor. I do agree with my colleague that the matter was technically raised yesterday, and I raised it at the first instance when I became aware that there was an issue of self-incrimination. I have, yesterday in fact, reviewed other documents on the case file, not just the statement of this witness. That suggests very clearly that there is an issue of self-incrimination. Now, I agree, perhaps we don't need to move into closed session. I could make reference to these documents by their document number, and I could very briefly explain why I think there's an issue of self-incrimination. I don't know if it's appropriate to do that in front of the public, given the comments that were made the last time I raised this issue. So let me be very clear. The application is based on the witness's statement that my colleague referred to, but also in conjunction, that is, with other statements of other witnesses on the case file. That, in my opinion, suggests that there is an issue, could be an issue under the terms of, let me correct myself, may be an issue under the terms of Rule 28.8 of self-incrimination. So I'm entirely in Your Honor's hands as to how to proceed here. I'm just trying to discharge my obligation under Rule 28.8, and I'm ready, willing, and able to explain that in camera if necessary.
The President, thank you, Counsel.
Your Honor, I should have mentioned this earlier. The reason that I raised this is because I may, I'm not saying I will, I may delve into these areas on cross-examination, and I didn't want to be accused at that stage of not having raised the issue at the appropriate time. So I may, as I said, I don't know yet whether I will, but I may go into it in cross-examination. And perhaps as a time-saving measure, I could simply send an email to all the parties outlining what I see to be the problem. Your Honors could review that during the break, and that would avoid going into the closed session if you were so inclined to do that.
The President, thank you very much, Counsel. However, Counsel for Nuon Chea is advised to provide the list of documents you would wish to raise during the examination of this witness, and make sure that the list of the documents are forwarded to the greffiers of the chamber so that the chamber is able to rule on how the proceedings would be conducted on this witness.
Thank you, Your Honor. I've done that already through the interface, whatever it's called. We have submitted the documents. Let me briefly just read out the numbers for everyone's reference. We submit the documents D224.14, D224.15, D125/143, D125/144, and D125/2.
The President, Counsel, who please be slower than this. You may repeat document from document number 3 you mentioned.
Yes, I'm sorry again, Your Honor. D125/143, D125/144, and D125/207. That last document is more or less a summary of the two previous documents, so really you could simply rely on that one. Our submission is that these documents, when read in conjunction with the witness's statement, one of the witness's statements, E187.1, that's the SOAS statement. That statement, read in conjunction with the documents I've just referred to, suggests very clearly to me that there is potentially an issue with respect to self-incrimination of this witness. Now, I don't think it's appropriate to give the factual scenario in open session. I could do that, but the witness isn't here. Would that assist?
The President, thank you for the information. I think it is reasonably enough for our consideration. Since it is now appropriate time for adjournment, we take a 20-minute adjournment. The Chamber wishes also to remind party that when the next session is resumed, we will conduct a in-camera session to address all the issues before we proceed to a public hearing. Public, please be informed. Counsel for Ieng Sary, Mr. Kanawas, you may now proceed.
Thank you, Mr. President, and good morning to everyone in and around the courtroom. My intervention is slightly different. There is one document, E187.1, which is an unredacted version of an earlier document. It's an SOAS quote-unquote interview. We sent an email to the senior legal officer making some inquiries regarding this document, which mysteriously has been retyped of a previous, it was retyped from a previous document. We don't know how it was generated. It's claimed to be an interview, presumably by Header, who is from SOAS. When one reads it, it's very clear that it is a summary and not an actual interview. We don't have anything other than this. And at this point in time, we would object to this being used. Now, the gentleman, or the witness who's about to appear, did provide an interview to the co-investigative judges, to their investigators. That too is a summary, but nonetheless, it's acceptable practice here. And we do have tape recordings of virtually all the interviews that we could review, which we do review, to see whether the summaries are actually accurate. On this one, this document, both the redacted and the unredacted versions, we have nothing to support that the interview or that the document itself represents exactly what was said, verbatim. There's no question, there's no answer. It's as if this person knew exactly what to say, and it's a simple summary. So we would object to this document being used. Unless, of course, the prosecution can provide us with more guidance as to how the document was generated, whether they are in possession of any tape recordings that we could review, or whether they can give us any other indicators that perhaps may alleviate some of our concerns. But at this point in time, we would object to this document being used for any purpose. Thank you.
The President, Counsel for Khieu Samphan first, you may now proceed. Counsel Kong Samon. Thank you, Mr. President, Your Honors. On behalf of Khieu Samphan, I strongly concur with the observation by Counsel for Ieng Sary. This document cannot be used to verify or to impeach the witness, as we have no proof that the document is obtained from the witness, and there is no mentioning on the document to prove that this was done officially, and that the document is a brief or summary of the interview, and we have no source to verify it. Since witness is summoned and will be appearing before the chamber, we may question the witness directly rather than referring to this document prepared by that person, and we can also refer to the written records of interviews by the co-investigating judges if we need to question the witness for verification, and we would like to reject the introduction of E181.1. The President, rather 187.1. Counsel for Nuon Chea, you may proceed.
Thank you, Mr. President. I don't mean in any way to quarrel with my colleagues on this side of the stage. I support their position, but perhaps, as I can confirm that document was in fact created by Professor Header, perhaps the best course of action is to have Stephen Header in the courtroom to give testimony on that document and the many other documents of which he authored, which are part of the case file. I believe that's an application we've made in the past. I think that would be entirely appropriate.
The President, International Co-Prosecutor, you may now proceed.
Thank you, Mr. President. We did indeed also receive Mr. Ieng Sary's notice of this application. And we oppose it on a number of grounds. First of all, there's no basis given for this application, no legal basis, that is, other than the argument that because it is a summary, it shouldn't be brought into evidence, and that because we don't have a full transcript, that this document cannot be used. First of all, that's not a rule that applies under the internal rules of this court, and is certainly also not applicable at the international level. And I'll refer to only two decisions which specifically hold that summaries prepared by non-parties are admissible, provided they bear the minimum indicia of reliability. And those two decisions are in Milutinovic, a decision on evidence of the 1st of September 2006. At paragraph 16, the trial chamber deals specifically with summaries and reports prepared by non-parties, such as the summary that is before you. And also in Gotovina, in its judgment, the trial chamber of the ICTY at paragraph 45 deals with the issue and indicates that it had admitted into evidence summaries prepared by third parties. Coming a little bit closer to the some of the arguments we just heard, of course the issue of admission of written statements is before the chamber. It was briefed last year, but it is relevant to note that the basis on which both Ieng Sary and Khieu Samphan objected to the admission of statements taken by non-court individuals other than officials of the court, the basis for that objection was that the witnesses must appear at trial. And so that's the position we're in. We have a document which we have the basic information as to its provenance and circumstances of its creation, and we have the witness. The witness, at least in part, testifies to the acts and conduct of the accused, and he is before Your Honours, and the defence can make use of this document. It is only appropriate that all prior statements of a witness who is before the court are also put before the chamber, and of course so that the parties can make use of them. We see no prejudice that could possibly arise from the admission of this document. The defence will have the opportunity to examine the witness and to ask him about this document if they so wish. Thank you.
The President, legal lawyer for the civil parties, you may now proceed.
Mr. President, once again, we have before us an example of confusion over admissibility and probative value. As Mr. Court Prosecutor has said, there's been no information or elements brought forward to us that would show that these documents would be inadmissible because they are summaries or something else, or that they have lesser value than any documents that have been admitted by the co-investigating judges. Now, barring any further debate on the issue of admissibility, I would implore you to reject this application put forward by the Nunchia defense. To say that we have to reject a document is absurd, because that would mean that all documents concerning this witness would have to be dismissed. And this includes written records of witness interview that have been conducted by the co-investigating judges. It is entirely routine and usual to rely upon these documents as we would any other document. Thank you very much.
The President, Mr. Kanawas, you may now proceed.
Thank you, Mr. President. Something must have been lost in translation. Nobody is suggesting that the document albeit a summary from the co-investigative judges, is not admissible. I personally find that the summaries are inappropriate, but we are in a system that allows these sort of summaries, however they may be. But the point is, we do have a tape recording of the actual interview from the investigators of the co-investigative judges, so that if we wish to check what was actually said, we're able to do that. Those of us who have been practicing for a while and have done actual investigations know that it is very easy to coach someone into saying something or to get them to agree to a position by suggesting the answer. That is why it is important. That's why it is important to be able to see what was the question posed, how was it posed, and what was the actual answer. And it is the question and answer that are relevant. It's also important to know whether the witness was shown any particular documents, if their memories were refreshed, if indeed there was a conversation with the witness in advance. Many times, if we have tape recordings, we're able to glean a lot more and to be able to demonstrate that perhaps the summary is not quite as accurate. It is neither accurate nor complete. Here we have a document generated by Header, who published a book where he named individuals who he thought should be prosecuted and are guilty. He then worked for the prosecution. He worked for the core investigative judges. He's obviously not just a non-party. He is a committed advocate who strongly believes that everyone is already guilty and does not necessarily mean that he has changed his position simply because he wore the hat of for the prosecution or the core investigative judges. We believe that a summary prepared by him, of all people, is suspect. That's why we maintain that it shouldn't come in. Now, the prosecution makes a point. First, they point to ICTY. And I find it rather curious that when I point to ICTY, I'm reminded by the bench that this is not the ICTY. When the prosecution does it, it appears that we should embrace that concept. That's number one. Number two, at the ICTY, I'm entitled to cross-examine, to ask leading questions. And this is rather common in civil law traditions. It may not be common in France or Cambodia, but in other civil law traditions, I can assure your honors, I am fully aware that parties are entitled to ask leading questions. So I'm not able to do that. So it poses some constraints. And that's why we cannot just simply adopt what happens at the ICTY. But lastly, should the trial chamber buy into the prosecution's argument, then we need some leeway, some additional time to go into those areas, which means that a time allotted for the defense, which I believe is 3/4 of a day, may not be enough. And so we may need some latitude from the trial chamber in order to challenge or in order to elicit information from the witness to see exactly how was the statement generated, whether he was shown any documents, and to the best of his recollection, what else he might have said at the time. So if the trial chamber is inclined to adopt the prosecution's position, then some leeway should be provided to all parties so we could see, exactly whether this summary accurately reflects what the witness said. Core investigative judge's statement, we have the tapes. We can verify it. This one, we do not. And there lies the difference. And that's why I raise it.
មានបញ្ហាអីទេ The President, does any member of other parties wish to make any further comment? If not, the court is now adjourned until 10 past 11. Parties and the public, please be informed that the next session at 10 past 11 will be in camera. And this closed session will be conducted until lunch break. Counsel for Ieng Sary, you may now proceed. Counsel Angadam. Thank you, Mr. President, Your Honors. I am here on my feet not to add any other new points on top of what my colleague already mentioned, but I wish to indicate that my client wishes to be excused and that he be allowed to follow the proceedings from his holding cell from now on until the remainder of the day. Thank you very much, Your Honors. Mr. Co-Prosecutor, you may now proceed.
Mr. President, I apologise. I don't wish to extend this debate any further. I think that the submissions are clear. I'll stop there. I just wanted to direct your attention to 3 documents which have in fact already been assigned E3 numbers and deemed put before the chamber, and which are from within this collection. They are E3/198, E3/392, and E3/393. All 3 documents are very similar in form to the document that we're discussing, and I believe they were admitted by the chamber since they were referred to in the relevant parts of the closing order, and I just put that on the record for Your Honours to assist in your deliberations.
President, the Chamber now decides on the request of Mr. Ieng Sary that has been made through his counsel. The Chamber grants the request that has been made through his counsel to waive his rights to present directly in this courtroom and to follow remotely, the proceeding remotely from the holding cell downstairs through audiovisual means for the remainders of today's proceedings. The Chamber requires that Defense Counsel for Mr. Ieng Sary submit immediately the waiver with a signature or thumbprint of Mr. Ieng Sary. The AV unit is now instructed to live the proceedings to the holding cell for this accused to follow remotely. Detention personnel are now instructed to bring these accused persons to the holding cell downstairs for him to follow from there. The court is now adjourned.